Hey, hey, out there in estate planning world, Paul Rabelais here. Another number 12 of our YouTube live presentations, 12 of 20 daily YouTube live presentations. Everyone's different, everyone's unique, different estate planning topic. Working on educating you and allowing you to get more peace of mind, set things up the right way for yourself, for your spouse, if you're married, for your kids, if you have kids, for your loved ones, so that you just don't have to worry. One less thing you have to worry about in this crazy world that we're in. Okay, I always cover a few things, and then as you don't know, if you've been on any of my other ones, I once I start, I get in a groove and I go. But I cover things for just a couple of minutes beforehand. We got some live chat. I like Williams. I particularly like the second one because really you did two things with that second how many Gators joke. You actually told a joke and you actually made a true statement. So I appreciate the love for LSU. I don't do this very often, but I think about it often. In fact, this year, 2020, it's been it went like this at the beginning of the year, and then it did this. And when it did this, kind of the peak was on January 13th of 2020. And you say, why January 13th, 2020? And I say, well, that was when that night I was actually in the New Orleans Superdome where my LSU Tigers beat the Clemson Tigers to win the National Football National Championship. And just because I'll only be able to do this maybe for a few more weeks, just to let you know, we had a pretty good season. Our quarterback won the Heisman Trophy, Joe Burrow, in the largest margin of victory in the history of the Heisman Trophy. Our team went undefeated, 15-0, and we beat something like 7 or 8 teams that were in the top 10 at the time that we played them. Of course, our victory over them may have bumped them down out of the top 10, but and then many people are saying it's the greatest football season in the history of college football. So thanks, William, for your comments there. Starting to see some questions come across the live chat. Can you explain a little on an irrevocable grantor trust? I'll get to that, Izzy. I'm glad you mentioned, can a grantor be the trustee along with a co-trustee on an irrevocable trust? I'll get to that one as well. All good questions, all really relevant to the topic at hand of this revocable versus irrevocable trust topic. All right, just answering maybe 2 questions that came in overnight on my estate planning YouTube channel. One is, let's see, Kenny, 5 hours ago and 6 hours ago had some nice comments. These are awesome videos. I'm almost finished my plan, and the video pops up affirming what I'm doing. Here's one from Pam, which is relevant, I guess, to, I don't know, one of the prior YouTube videos or lives. Do the allowed $15,000 annual cash gifts count as transferred assets that trigger the Medicaid 5-year waiting period? We get that question a lot. Here's the deal on that. Pam D'Estacio. Okay, Miss Return, I'm getting a message from YouTube that the connection is unstable. Looks like we're good to go here. Any transfer that someone makes, whether it's a transfer of $15,000 or a transfer of assets that have a value of $100,000, or quite frankly, a transfer of a $50 birthday gift or Christmas, the $15,000 gift tax annual exclusion amount, it doesn't do much for helping people qualify for Medicaid. But because if people are simply just transferring $15,000 to their children, to their grandchildren, they're still holding on to maybe the remaining assets in their estate, which might consist of an estate of $300,000 or $1 million. If they're giving away $15,000 a year to different people, they probably have, still have an amount in their estate. And so Medicaid eligibility planning, it's kind of an all or nothing thing. You either get all of the assets out of your estate in some form, and that's a topic for another YouTube live presentation, whether they go to other individuals or into trusts for the family. start that 5-year period running so that when a Medicaid application is submitted years later, when someone enters a nursing home and they ask, have you made any transfers to anyone in the last 5 years? You can say no, because more than 5 years ago, you got everything out of your name. But if you're making these $15,000 annual exclusion gifts and you're doing it on an annual basis, and then one day you go to a nursing home, have you ever transferred anything out of your name in the last 5 years? Yes, I've made these annual $15,000 contributions, which causes a big stir. You probably still have other assets in your estate that are a problem. So know that the $15,000 thing really doesn't fit from a Medicaid eligibility standpoint. That's more of an issue for the wealthier folks who are trying to get assets out of their estate for estate tax purposes, which we're going to talk about here today. All right. Ever consider adding using a whiteboard to illustrate number of scenarios? I'm mean, you're a good looking dude and all, but the data is the data. Well said. I have considered it. I don't have one. I haven't done many of these YouTube live presentations. I don't. So I've had one or two others in the past suggest I use a whiteboard when I do other videos that I record and then put on YouTube. I can kind of do some editing and either use a whiteboard or use a PowerPoint or show a Word document that has lists or mathematical calculations on it. Probably the real reason is I'm a little bit lazy. I'm a busy guy working, and I just jump on these things and I just talk. But I completely agree that that could add a new, kind of dimension of helping people learn, because some people learn by, looking at whiteboard stuff like that. So I have a feeling I'm going to get to that level because I'm so impressed with the participation that I'm getting. We've had in the first 11 YouTube live presentations. I know not all of the people have viewed it live, but some roughly 2,500 have viewed 11 presentations. Appreciate the feedback, Ron, but we can always get better at what we're doing, and I really appreciate Johnny's comments there. Okay, getting another YouTube that our connection is unstable. This is the one thing that I don't like about YouTube. I am completely dependent on YouTube for the technology working, but I sacrifice that because I sacrifice being subject to YouTube's technology that goes in and out. I'm kind of okay with that because the beauty of this is YouTube records the presentation and they'll put it on their website so that people can search it and find it. And for people who can't watch it live, they can watch a recording of it. So really like the YouTube live aspect of it. Okay, now we begin. There was another question or two, maybe one more question that I wanted to answer that came across Pam. That was 9 hours ago with $15,000. Here's another good one. One from April. April Fletcher, 16 hours ago, wrote in a comment, don't you still need 2 people to prove the handwriting is authentic before the will is accepted as valid for probate? Great question, April. Yes, you're right. So my days are running together. Either yesterday or the day before, I did a YouTube live presentation about handwritten wills being valid. And in many states, about half of our 50 states, about 25 states, people can sit down, write their own will in their own handwriting. They don't need anybody else. They don't need a notary. They don't need witnesses to make it valid. And of course, the content is super important. But as far as meeting the validity requirements, there really are few. Most states say it must be, entirely dated, written, and signed in the person's handwriting. But April asked, don't you still need 2 people to prove? Yeah. So most states, I know in my state of Louisiana and in the other states that I've either had experience with or have researched, after the person who did the handwritten will without a notary, without witnesses, dies, then in many states, 2 people after the person dies, and it's typically family members, have to sign an affidavit where they recognize the handwriting as the testator's handwriting. It's proof to a judge, perhaps, that the handwriting on the piece of paper is the actual handwriting of the person who died and is, alleged to have written the will. So yes, there you go there. All right. So now we'll jump into it. Feel free to jump on some live chat if you got something. Contributions are welcome. I glance at it every once in a while just to see what comes up. I often stop right in my tracks to address the questions that come in the live tracks. What's the difference, Paul, between a revocable and an irrevocable trust? And I just kind of, like many questions, I've repeated myself many times. Some of these questions I get, I just kind of cringe when I get them. And I don't answer them because I could go in a million different directions with it. I need to dig deeper and ask, why are you asking me that question? And for some people, they might say, well, my neighbor told me to ask you that. And for others, it's just curious. And so the stupid answer to that question is, well, you can amend or revoke or change a revocable trust, but you can't amend or revoke or change an irrevocable trust. That's the stupid answer. And that's the obvious answer, but that's not the practical answer. So I want to give you all the practical stuff today. Can I just notarize a handwritten will? Good question, DKS. So like in my state, you can have what's called an holographic will as long as it's entirely written, handwritten, dated, and signed in the person's handwriting. It's valid, no notary witness requirements. Or you can have what's called a notarial testament, which is written up 100% of the time. They're typed. It has certain language at the end of the will that's required to be in there. And then it is notarized and it's witnessed by two people and it's signed on every page. So you're either going to have an holographic will, which is in your handwriting, doesn't need to be notarized or witnessed, or you're going to have a notarial testament, which is has what's called an attestation clause in it at the end. It's notarized and witnessed by two people. Those are typed up all the time. But to really answer your question, you could have a notarial testament that is handwritten, and it will either meet the requirements of a notarial testament because it'll have all the extra stuff that a notarial testament needs, or it'll meet the requirements of a holographic testament. So probably too much information there, but we're going to keep going. Hope that helps. All right, so I mentioned the stupid answer to what's a revocable versus an irrevocable trust. Revocable you can change, irrevocable you can't. But really, I want to get into some of the practical stuff. Stopping in my tracks here because I just love the live chat. When we get too much live chat, which we hadn't gotten in 12 YouTube live presentations, I'll finish the expected presentation and then come back to the live chat. Are banks generally adverse to an irrevocable trust as opposed to revocable trust? Also, what portions of the trust itself should or shouldn't be divulged to a financial institution? Thanks in advance. Oh, New Age, that's a tough one. I think banks are very, very familiar now with revocable trusts because so many Americans, in an effort to avoid probate, they have established revocable living trusts. They have gone to the bank to retitle their bank accounts into the name of their revocable living trust. And with a revocable living trust, the bank doesn't need a tax ID number for the trust. The bank still uses the social security number of the previous account owner and settlor of the trust as the bank's tax ID, as the account's tax ID number. Banks are just familiar with the concept of creating revocable living trusts in order to avoid probate and continuing to use the social security number on all accounts. They're familiar with it. And as banks are presented with things that they are not familiar with, I think they get nervous. So when they are presented with an irrevocable trust, and they are often, but there's many different kinds of irrevocable trusts. Some of those irrevocable trusts require their own tax ID number, which is not a big deal, but it can be a big deal when people walk into banks and banks start pulling out their procedures when they see certain words on certain documents. And, what portions of the trust itself should or shouldn't be divulged to a financial institution? Well, a financial institution is going to need some information. They're going to need some documentation to prove to them who is the trustee of the trust. For example, who has the authority to open an account in the name of the trust. So sometimes that information is all contained in the trust extract, or sometimes people call it a certificate of trust, which is a very short summary of the relevant provisions of the trust, often used for recording in the real estate records so that title examiners can determine who a trustee of a trust is. Sometimes the information on that extract or certificate of trust is sufficient. Many financial institutions will say, we need a copy of the first page of the trust or the title page, and we need a copy of the signature page of the trust. So every financial institution can be different. It's just like, unless you want to move the money to another financial institution, you just have to give them what they're asking, not necessarily anything more or anything less. But banks are large institutions, and they're not real crazy about making exceptions to their policies and procedures, even when those exceptions make common sense. So again, not knocking financial institutions, but they're just, they're large, and because they're large, they have to have policies and procedures. And sometimes in the estate planning world, things that we do that are a little customized or unique don't check the box that the bank has, and so we just have to do more communication. All right, do you change all your checks when you retitle your revocable trust on your checking account? Now we're starting to get into, I'm going to answer it real quick, but because I've got another YouTube live presentation coming up, you can look it up on my website, that will talk exclusively about what to do with your bank account so they don't get frozen. Some people do make their checking account, they do actually retitle their checking account, and it depends whether you're required to get a new account number. And if you did have to get a new account number, you'd have to get new checks. Before I get into what you have to do if you put your checking account into a living trust, let me just mention some people kind of skirt around the frozen account problem by setting things up a certain way and keeping their account titled like it is. So I know, grandma, before she dies, she goes and takes her daughter to the bank, adds the daughter as another signer on grandma's account, checks with the bank and says, hey bank, if I die, which I'm going to die, can my daughter still access the funds? Maybe the bank tells her yes. That's her kind of practical way of making sure her account's not frozen. Some banks permit POD designations, payable on death. So some people get around the bank account going through probate by making a POD designation, all good stuff there. How does the will impact the irrevocable trust? In other words, my will says a bunch of stuff. So if the will says my estate goes to Jack when I die, and the trust says trust assets go to Jill when I die, then the trust assets are going to go to Jill, regardless of what the will says, and the assets in the estate in the name of the deceased owner, will go through the estate to Jack. Many wills say, pour-over wills say, I have this trust, and if there's anything in my name when I die, I leave those assets to my trust. So then those estate assets wind up going to the trust for distribution pursuant to the trust terms. And you guys are rocking and rolling here on a Wednesday. Fantastic that we got the involvement. So going back to the revocable versus irrevocable trust. What I want to do is be as practical as I can. Excuse me. And I will tell you that in general, kind of the revocability or irrevocability of a trust is going to depend on what the person who is setting up the trust is trying to accomplish. For the rest of our time today, I'm going to call the person who is setting up the trust, I'm going to call them the settlor. It could also be called a grantor. It could also be called a trustor. So the person setting up the trust, I'm going to call that person for the rest of our presentation the settlor. So let me give you a couple of quick practical explanations of why someone would want to use an irrevocable trust versus a revocable trust, because irrevocable doesn't sound real appealing to some people. Irrevocable, they tell me irrevocable to me sounds like I can't change anything. And quite frankly, in general, they're right, subject to certain things we may talk about here in a minute. So people don't really like the idea of irrevocable if they can avoid it, but in some cases they can't avoid it. Let me give an example. This doesn't apply to many people, but it's an ideal example. We have an estate tax. I talked about it, I think, yesterday. My days are running together. And so some people want to get assets out of their estate so that when they die, those assets are not subject to the 40% federal estate tax. For most, that makes some sense. Yes, we have an $11.58 million exemption, so that the estate tax doesn't apply to hardly anybody. But when it applies, it's a 40% tax, and people want to try to avoid it. So grandpa, for example, who has a large estate and he wants to try to avoid estate tax, he's got a bunch of grandkids. Yeah, he could give $15,000 to each of his grandkids every year, but he's saying to himself, I don't want to give my 18-year-old grandkid $15,000 every year, because my grandkid, he doesn't know how to manage money. He's going to blow it, and that would do more harm than good than if I wrote him a check for $15,000. But then he says, well, I'll tell you what I'll do. I'll put it in a trust for him, and it's likely called a crummy trust. I've done other videos on that. And I'll put it in a trust for him, and I'll do it every year, and I'll be getting assets out of my estate. And I'll set up the trust so that, when my grandson is 30, he can get a third of what's in the trust. When he's 40, he can get 1/2 of what's left. And when he's 50, whatever's left in the trust, it's all his to have. But he's not going to get it when he's 18. In fact, I want him to work for a while. I don't want him to have access to any of that trust principal until he's 30. Okay, because grandpa's probably saying, I wasn't really responsible until I was 30. I messed around. I made my mistakes. I blew some money. I partied too much. I got married. I got divorced. I bought vehicles that I couldn't afford. I did all that before I was 30. And then once when I was 30, I got married. I started having children. I started getting more responsible. So, people often base what they do for their descendants based on their own life experiences. So that trust that grandpa contributes to on behalf of his grandchild, and he might do the same thing for all of his grandchildren. Perhaps he has 15 grandchildren, does it for all of them. That trust, to get the assets out of grandpa's estate for estate tax purposes, that trust has to be an irrevocable trust. Grandpa can't have the right to say, you know what, I put some assets in a trust for my grandson and he's not turning out too good. I'm going to dip into that trust and take those assets back and put them back into my name. If grandpa had the right to do that, then those assets in the trust would be part of grandpa's estate for estate tax purposes. He can't retain any strings over those assets that have been transferred to his grandchild's trust. It has to be an irrevocable trust. Grandpa can't have the right to revoke it, undo it, change it, and put assets back in his name. So to get the advantage of avoiding the 40% estate tax, that trust that grandpa donated to had to be an irrevocable trust. Let me give an example of a revocable trust. Clearly the most common, I've already mentioned it once, the most common form of a revocable trust. And the words sound so alike, revocable, irrevocable. I always have to say revocable starts with an R. So the most common form of a revocable starts with an R trust, as opposed to the irrevocable starts with an I, is just your standard avoid probate revocable living trust. Now, to get that benefit of avoiding probate, that kind of trust, you're just trying to get the assets titled out of your name and into the name of a trust, because when you die, the government doesn't want to supervise the distribution of trust assets. They only want to oversee the distribution and management of assets that are in your name when you die. That's what the probate's all about. So all they've got to do, that's really the only requirement. Those assets just need to be in a trust. And yeah, you want the terms of the trust to be correct to determine, where the trust assets go and all of that. But you can still accomplish all of those avoid probate benefits, even if the trust is revocable up until the date that you die. So there is no requirement that that trust be irrevocable to get that benefit. So maybe now you're starting to see of not only the difference of the difference between the two, but why certain ones are used at different times. I will tell you, just in case you're looking at a trust, in the absence of a statement in the trust that states whether it's revocable or irrevocable, it's irrevocable. At least in our state of Louisiana, every state has its own trust rules, but this is reading from a provision in our trust code. A settlor may revoke a trust in whole or in part only if he has reserved the right to revoke the trust or an unrestricted right to modify the trust. So a right to revoke is there only if it's reserved in the trust instrument. So real important thing to look at. I did a video once of 10 important provisions that revocable living trusts need to have. And if that was not one of them, it needs to be one of those provisions. All right. So I'm just glancing at live chat here before I get back to more of the typical kinds of revocable versus irrevocable trusts. I've heard so many good stuffs on irrevocable trusts, but no one talks about negative aspects of irrevocable trusts. What are some of the drawbacks of these trusts, tax consequences, paperwork, et cetera? Okay, I'm gonna get to that here in a second. All right. All right, so let's talk through the typical revocable trust, and then I'm gonna get to Happy Me and the irrevocable trust. I already mentioned it twice. Typical revocable trust, avoid probate. It's dad transfers his assets to dad as trustee of the revocable living trust. The trust instrument says dad can amend, revoke, change the trust anytime. It says that while dad is alive, dad gets all of the income that the trust assets produce. Probably says something like when dad dies, dad's 3 children or whoever dad would have wanted are entitled to the trust principal. Trust will also say that when dad dies, person A or person B will be the trustee or co-trustees of dad's living trust. A key component is the living trust. This sounds bad, but it just makes sense, and it's got to be this way, that dad's revocable living trust becomes irrevocable upon dad's death. That makes sense because dad, think about it, dad would want his revocable trust to become irrevocable on the date that dad dies. And that way, because if somebody had the right to change dad's trust after he dies, somebody could change the dad's intended distribution schedule of assets. So now it's clear, so-and-so is the trustee, so-and-so has these rights, these obligations, here's the principal beneficiary. So it's all laid out. Trustee just has to follow dad's wishes as described in his revocable living trust instrument. So now sometimes you'll see revocable living trust used in a scenario where maybe dad dies and now it's mom who is not real financially savvy. Dad did a great job. He invested his money. He has maybe hundreds of thousands or millions or more of investments, has brokerage accounts. Mom never dealt with it. Mom doesn't know anything about it. Mom doesn't want to understand it. And so mom might say, you know what, I don't want these assets to be in my name. I want our son to manage these assets. So I'm going to put all of these investments at the brokerage firm in a revocable trust. I'm going to name my son as the trustee. And now the son can work with a broker, can buy, can sell, can manage, can invest. And mom doesn't have to worry about it. Mom's assets are in a revocable trust. If she doesn't like what son does, she can amend or revoke the trust and remove him as trustee. So sometimes we see that when a person just wants someone else to have all of the management authority over their assets. Trusts are used for that sometimes. So revocable trust, really common, really common for avoid probate purposes. I've done other videos on that. Now let's get into when irrevocable trusts are used primarily. I'm going to give you 3 reasons why irrevocable trusts are used. All of them are common, but all of them are a little unique. And it's not just enough to say, oh, thank goodness, it's in an irrevocable trust. It's all protected from whatever we're trying to protect it for. So it not only, in many cases, needs to be in an irrevocable trust, but you have to dig in and look at the actual terms of the irrevocable trust to still see if you're accomplishing what you're trying to accomplish. All right, happy your mom, there you go. So your wife is like the mom I just described. Well, that's a good thing. Maybe you're doing a good job, and mom's doing the mom thing, which is great for mom. Congratulations, mom. Typical irrevocable trusts. 3 reasons. 1, I mentioned already, avoid the estate tax. I'm not going to get into that too much, but yeah, I'm going to get into some of the exceptions here on the next one. Grandpa has a lot of assets. For purposes of 2020, more than 11.58 million, or he expects to have more than 11.58 million, starts transferring assets out of his estate into trusts for his children, for his grandchildren, for whoever he wants, his great-grandchildren, shoveling assets out of his estate and getting them at a place where they will not be subject to the 40% estate tax when he dies. That trust has to be irrevocable. It could be many, many trusts. It could be one trust, but nonetheless, it's irrevocable. Grandpa can't have the right to go in and get those assets back. A second reason people use irrevocable trusts is for Medicaid eligibility purposes. So the thought process going through many seniors' minds, typically they're thinking about this hard when they're maybe 70 years old, 75 years old. They know they're not going to live forever. They've got some ailments. They don't want to be a burden on their children if they get sick. They don't want to have to go live with their children. They don't want their children moving in with them. They realize one day, as much as they don't like nursing homes may be a necessity. And they know enough to know that if they have assets or resources in their name when they go into a nursing home, they're not going to be eligible for any kind of Medicaid benefits. They're going to have to pay 100% of the cost of that nursing home out of their own pocket. It may be $8,000 or $10,000 a month, double that if you're a married couple, and until your assets get down to, let's say, $2,000 for Medicaid eligibility purposes. So many people say, I don't want to put my assets in my kids' names because I lose control. I'll put assets into what I call a Medicaid trust. It's an irrevocable trust. But again, not every irrevocable trust is set up in a way to enable the person who put the assets in the trust to qualify for Medicaid. So in theory, there could be an irrevocable trust that mom and dad set up. And that trust says that the trustee can use their discretion to give assets back to mom and dad, all within the confines of that irrevocable trust. Well, if that irrevocable trust gives mom and dad too much power, too much or access to trust principal, then yes, it's an irrevocable trust, but it's an irrevocable trust that wasn't set up correctly. So mom and dad still are not going to be eligible for Medicaid if and when they go into a nursing home. So my point there was, don't stop the analysis once you look at whether the trust is revocable or irrevocable. You have to look at the other underlying terms of the trust instrument to see if it complies with the rules for the objectives that you're trying to accomplish. Okay, so that's the second use for an irrevocable trust. First one, avoid estate tax. Second one, avoid or gain Medicaid eligibility. And then the third one we see quite often is this: I want to protect my assets from lawsuits. So as you can imagine, could be doctors, could be lawyers, could be people who drive cars, people who own businesses. There's a certain element or class of people that are others, and they want to know what they can do to protect their home, their life savings, their CDs, their business, their rental property. They want to know what they can do to protect themselves. Yes, they have liability insurance, but someone may get a $15 million judgment against them, and the insurance liability protection only protects the first $1 million or $2 million of damages, but they got a $15 million judgment against them. So their personal assets must be used to satisfy that judgment. What can I do to avoid that? Many people make an attempt to put their assets into an irrevocable trust, done timely, done properly, do it right the first time, do it before there's a problem. And then those assets in that trust for the benefit of others or other family members can be protected from judgments against the settlor. So a revocable trust doesn't do any good there, because if you put assets in a trust that you have the right to undo and just put back in your name, then if you get sued and you owe somebody, well, then a court is going to say, hey, you have the right to undo that trust and put the assets back in your name. We're going to require that you do that. You exercise that right that you have so that those assets can be used to satisfy this creditor that you have. So assets for creditor protection purposes or lawsuit protection purposes are also typically irrevocable trusts. And then there's trusts set up for people with special needs, people getting certain government benefits. Again, those have to be irrevocable trusts as well, so that the person who's getting government benefits can continue to get those benefits, and those trust assets can be used only for special circumstances, and the provisions of the trust can't be changed. So that's all that special needs trust stuff. Here's a big one. Probably the biggest one of all, because it's common and it's not well known. It's the, and look, before I get into this, I will ask you to smobliterate. I was going to say smash and obliterate. Smobliterate the like button. You've got a gray like button, thumbs up button. Gray is just a color that doesn't, to me, seem real happy. We want to make it blue. So click on the like button. Let's go from 8 to 9 to 10. And then that makes me happy, and for what that's worth. And it also makes YouTube happy. That's who we want to keep happy. If we can keep smashing the like button and keep subscribing, that makes YouTube happy. That's you telling YouTube, hey, I kind of like Paul's videos. Will you show them to more people? Which makes me happy. And that's all we want in the world, is happiness. Okay, this is the most important to me. Most important. It all depends on your circumstances, but this is a very for married couples. Married couples, I've mentioned it at least 3 times, maybe 4, often set up revocable living trusts so that when they die, all of the court and attorney involved probate proceedings are avoided. And even when they set up wills, this issue becomes important. So, I'm going to give you the layman's version of it first, and then you can tell me in the live chat whether you think it's important and whether you understand it. So let's say husband and wife have $2 million. That's the size of their estate, $2 million. And let's make it easy. It could be a community property estate, or it's not, and they own it 50-50. Each husband and wife each have an estate of $1 million, and they have some kids that they want to ultimately leave things to. All right, so the question becomes, what becomes revocable or irrevocable upon the death of the first spouse? And it's done both ways. There isn't a right or wrong here. This is a personal decision, but it's an important one. So many husband wives out there, they set up the husband and wife revocable living trust. They put all of the assets in their trust. And on the revocable side, the trust might say that when the first spouse dies, and let's say husband dies first, then the entire trust is revocable by the surviving spouse. And when the surviving spouse dies, the trust assets go to the 3 children equally. But the surviving spouse has the ability to revoke, amend, change that revocable trust. Husband dies, things stay exactly where they are. There's no probate. Mom's the trustee. The trust instrument says she can revoke, change, amend. She meets new husband. Her children do something to tick her off. She has the right to amend the entire trust, not only her portion, but husband's portion as well, because he gave her that right. That's what the two of them decided when they initially set it up, or maybe it didn't even decide it. It was decided for them by the attorney, not the best scenario. And wife then amends her trust to leave everything to either her new boyfriend, her new husband, her new stepchildren, and the children of the first marriage get excluded. Now, on the other hand, maybe husband and wife say, we want the surviving spouse to be able to amend the entire thing because we don't know how our children and grandchildren are going to turn out. We know, at least we feel confident that the surviving spouse isn't going to do something stupid like leave it to someone other than our children, but we want the surviving spouse to be able to control the entire disposition of schedule and everything. That way, the surviving spouse, if one of our kids is on drugs, they can exclude that spouse, blah, blah, blah. So it kind of works both ways, but at least that husband and wife was able to make the informed decision to make the entire trust completely revocable by the surviving spouse. Then there's the other scenario. That scenario is, I'm going to get you to happy in a minute. That scenario is husband and wife get together. They set up their revocable living trust. They have $2 million, $1 million each. And the husband's thought process, or maybe both of their thought processes, but I'm saying the husband's going to die first. So I'm going through the husband's thought process. Maybe he or she is thinking, you know what? I've got $1 million. My wife has $1 million. We've built this together. If I die first, I want my $1 million of assets to be available to my wife if she needs them. And she might need them for her typical standards, health, education, maintenance, or support. And if she needs them, I want her to be able to use them. But I don't want her to be able to leave any remaining assets that were mine to somebody else. So when husband dies, I want my estate planning documentation to read that my portion of the trust becomes irrevocable when I die. My wife can be the trustee. My wife can be the income beneficiary. If the trustee determines that my wife needs principal distributions for her health, education, maintenance, or support, she can use them, but what's left in my portion of the trust when my wife subsequently dies must go back to my children. My wife does not have the right to amend where my trust goes when she dies. Nothing wrong with that either. There's not a right or wrong here. But some married couples want that surviving spouse to retain that 100% control. And some married couples say, they either say bluntly, I don't want my spouse leaving my assets to someone else. I want to make sure they wind up going to my children. Or maybe more politely, they're saying, we're going to set up our trust so that after one of us dies, the survivor can't be influenced as they perhaps lose cognitive ability and get dementia. We want to protect ourselves from making a stupid mistake that we might get influenced to make. Let's put these protections in place for our children so that after one of us dies, the children know that they will at least get the remaining assets of the first spouse to die. And unless the surviving spouse changes things, they'll also get the remaining assets of the surviving spouse to die. Okay, now I'm skipping forward. Louisiana must be the happiest place on earth. It is a happy place. I don't know. Tell me why you said that, Ron, because Louisiana kind of gets a bad rap in a lot of areas. In these areas where they rank states from 1 to 50, whether it's education or health or whatever, sometimes we're in the high 40s, if not number 50. But hey, we got the Tigers, and that's all we need. But we got a lot of great stuff too. Crawfish bowls, good weather, really phenomenal people, and and just, all kinds of great traditions and great, really, really nice people. So anyway, thanks for your comment. Kind of came out of the blue. I know you're in Wyoming, and Wyoming's maybe the second happiest place on earth. All right, happy me. Can a revocable trust be perpetual even after the death of trustors? Can it be made revocable trust again with beneficiaries as new trustors and their children as new beneficiaries? Could be. So let me just, I kind of like to apply it to an example. Let's say mom and dad have a trust that says when they die, their assets will remain in the trust for the benefit of their children. And maybe the children are the trustees of their own portion of the trust. And maybe the children can revoke or amend their trust. And maybe it even says that when the children die, that children's share, what's left of it, goes on down to the child's children. So all that, can be in one trust instrument. Or if mom and dad have child A and child B, they could set up the mom and dad trust, and they could also set up the child A trust and the child B trust and say when we die, assets go 50-50 to the child A trust and the child B trust. Maybe they just leave the assets to child A and child B, and then child A and child B can then set up their own irrevocable trust according to their wishes with the inherited assets. So all of those things are permissible, but we just have to dig a little deeper. I kind of answer the question based on what I read, and sometimes I don't read it in the right context, but there we go. And again, state law issues here are out there as well. Some states allow trust to go on for many generations. There are limits on how long a trust can last. Here in my state of Louisiana, essentially I think it's well, I'm not even going to go there, but most trusts in Louisiana last for 2 or 3 generations, and don't go much beyond that, but that's a general statement, and we'd have to look at the circumstances. Okay, so kind of there you have it. Revocable trust, when you can accomplish what you're trying to accomplish and have your trust be revocable, when the objective that you're trying to accomplish requires that a trust be irrevocable or can't be changed, maybe for estate tax purposes, maybe for Medicaid eligibility purposes, maybe for lawsuit or asset protection purposes. Those are typically irrevocable trusts. It goes beyond that. Having it state that it's irrevocable often isn't enough. You have to look at the underlying provisions of that trust to make sure they satisfy whatever objective that you're trying to accomplish. Tomorrow's YouTube live presentation, I can't believe we're now 60% done through 12 out of 20. It's been a lot of work. I'm so glad I've done it. Thousands of people have viewed. It's forced me to up my game a little bit with the research and the making my best effort at communicating these issues. I got to feel like with thousands of views, we've helped some people out there. You've helped with your live chat and your questions and your support. Really amazing. So tomorrow's all about a lot of abuse out there with powers of attorney. Powers of attorney are often kind of, yeah, here's what I want to happen when I die. Let's talk about that for the next hour and a half. And oh, by the way, I want to give so-and-so power of attorney, and that conversation lasts like 15 seconds. So, and I'm not saying that's wrong, but a lot of the problems with estate planning start with power of attorney problems. So we'll be talking about kind of a deeper conversation on that, what you need to watch out for, what you need to consider, how to do it right. And so that'll be tomorrow. I have to do a little prep work to really be on my A game tomorrow. Love the live chat. Let's see, do I need to go back and get any of these? Okay, I missed one. Alex, is it legal to move excess monthly income from a regular bank account to an irrevocable trust? So yeah, and this is one of those answering in context. Is it legal? It's not illegal. It's not a crime. Person perhaps has created an irrevocable trust, and as I read your question, I'm kind of reading into it. They probably did it for some Medicaid eligibility purpose, but they keep getting income from their pension, from their Social Security, because that has to be paid to them. That can't be directed to some other third party or even some irrevocable trust. So yes, certainly as that income goes into the individual's account, and sometimes that individual doesn't spend it on their living expenses, so it accumulates. And then sometimes that individual wants to protect that excess money, perhaps from future nursing home expenses. So they transfer the excess accumulation into their trust. Can they do that? They certainly can do it, but it just has Medicaid eligibility consequences. So if they set up, originally established their trust 6 years ago, but 6 months ago, they transferred, $25,000 out of their personal account into their trust, and then they go into a nursing home and apply for a nursing home, and on the nursing home long-term care Medicaid application, it asks, have you transferred anything out of your name in the last 5 years? You're thinking to yourself, okay, we did this stuff 6 years ago, all that's protected, but 6 months ago, I had too much money in my checking account, so I transferred $25,000 to my trust, so you have to disclose that. That's gonna trigger an ineligibility period for Medicaid. That is really the topic of another webinar or video that I've done before, and you can go check out. So legal, yes. Does it have Medicaid eligibility consequences? Yes, as well. All right. All right. You had just said you want to, yeah, okay. Y'all have a great day. We'll see you tomorrow. Tune in. One more favor, share this stuff with others. Invite them to join. Invite them to subscribe and like and chat and all that stuff. We want to talk to a lot of people. We will see you tomorrow. Ending the stream, 3, 2, 1. I think we got all the questions. If not, I'll give them more. Add more questions on comments to videos, and I'll answer those as well. First thing out of the box tomorrow. Bye. Like, subscribe, notification bell, all the good stuff I try to sell you on. If you live in Louisiana, you can click on my website, 15-minute call, schedule it. You go to my calendar. I give you a call at the prescribed time. I got to get out of here. See ya.